Hello everyone. Welcome to an episode of Lessons of Law. Today, we are going to briefly explore a few key legal issues when a company or an individual uses generative AI technologies. We first start off with the generative AI model itself. Then, we consider the data we are inputting into the model. You may also refer to this as prompts. Next, we need to consider the output that is produced by the model based on your inputs or prompts. Let's examine the first process relating to data input. When you are providing information to the generative AI model, you need to be careful not to input your company's proprietary information unless there are legal and technical protections in place. This is because, without any protections in place, the generative AI model may be able to use all the data you are feeding it and provide similar data to others, including your company's competitors. An example of a legal protection is to include a clause in the relevant contract to state that the generative AI model cannot use your company's data to train its model. An example of a technical protection is to host the generative AI model in a private cloud environment, or to house the generative AI model in-house, such that no data leaves your company's servers. We now move on to consider the next step of the process, where we receive data outputs from the generative AI model. The first thing we need to consider is whether the output is the same as, or substantially similar to, existing third-party intellectual property, or IP. If the output provided is similar to existing IP, and you or your company incorporates such output into your final product or service, then this might make you or your company liable for IP infringement. For this risk, again, there are legal protections and operational protections that one can consider. An example of a legal protection is to ensure that you obtain an IP indemnity from the generative AI model service provider. An example of an operational protection is to ensure that there is a human or machine reviewer to scan the output for any potential IP issues. Other than existing IP, in relation to data output, we also need to be aware of the contractual nexus. This means that, in the contract with the generative AI model service provider, you would have agreed to a set of do's and don'ts. You need to be aware of the contractual permissions, as well as the contractual restrictions, and abide by them. For example, the relevant contract may allow you to use the data output and display it on your website. However, the relevant contract may prevent you from using the output to attempt to reverse engineer the process, to understand the underlying algorithm, and to develop a competing generative AI model. Finally, we should also consider legal issues when we deploy AI in certain fields or certain parts of decision-making. For example, depending on the limitations of the generative AI model and the purpose for which it is being deployed, it could lead to legal issues relating to anti-discrimination laws or regulations. As another example, deploying AI to make sensitive decisions that affect a person's livelihood may also lead to legal issues, depending on the relevant laws and regulations. There is no easy way to mitigate against such legal risks. The solution needs to be holistic and requires a tailored approach, which aims to understand the limitations of the AI, and to allow for human intervention in areas where the AI falls short. That's just a small drop in the ocean that is generative AI. Feel free to scroll back on this video if the explanation was too fast. You can also leave a comment if you want to ask any questions. Happy learning!